We continue our discussion of due process now, but in an entirely different context. That is, in the context of information gathering. One of the main tasks of administrative agencies, of course, is making sure that regulations and laws are being complied with. And in order to do this, they conduct investigations and gather information. And of course, this can create constitutional problems because sometimes they're looking for evidence of law breaking. And so there are two constitutional provisions you're probably familiar with that we'll be referring to in this lecture. The first is the Fourth Amendment, which of course prohibits unreasonable search and seizure. The second is the Fifth Amendment, which protects people against being forced to incriminate themselves. And both occasionally come into play in administrative law. Now, one way in which agencies, public agencies, gather information is by demanding and requiring that companies and nonprofits and other institutions keep records and issue reports to the government. This is requiring these entities to turn over information. And of course, sometimes this information can be used to detect evidence of wrongdoing. And nevertheless, we don't really need to spend a whole lot of time talking about record keeping and reporting because the courts have said that yes, indeed, record keeping and reporting are permissible. They are not a violation of the Fourth Amendment or the Fifth Amendment if conducted under certain circumstances. First, the agency that is requiring the record keeping and reporting must have jurisdiction over the area. The record keeping and reporting must be reasonable and not overly burdensome, and of course there may be disputes about whether particular reporting and record-keeping requirements are overly burdensome, but generally the agencies can satisfy this requirement. And the government can't require privileged information, so trade secrets and attorney-client privilege, things like that oftentimes are exempt from record-keeping and reporting requirements. But for the most part, this is routine, and companies, nonprofits, and others can't use the Fourth or Fifth Amendment to shield their records if these requirements are met. There is a case in your textbook on this particular concept. It's a fairly easy case to understand, U.S. v. Morton Salt, so we will discuss that in class. The Fifth Amendment says no person shall be compelled in any criminal case to be a witness against himself. So the Fifth Amendment, by its terms, is limited to criminal cases. It doesn't apply to civil cases. So, for example, that's why O.J. Simpson had to take the stand in his criminal trial, in his civil trial, but not in his criminal trial. Now, as a result, it doesn't apply in a lot of circumstances with regard to public agencies because public agencies, as I've mentioned before, usually are bringing civil enforcements rather than criminal enforcements. But nevertheless, even while those kinds of investigations are going on, evidence of criminal activity may be uncovered. So I want to talk just for a moment about the concept of self-incrimination and a wrinkle that comes up in the context of administrative agencies. In 1937, the federal government, for the first time, clamped down on marijuana, and they passed the Marijuana Tax Act of 1937, which imposed a tax on marijuana. It didn't actually make marijuana illegal. As you may remember from our discussion of the Interstate Commerce Clause, that would be an exercise of the police powers. At least that's what they thought back then, and that the federal government didn't have the power to issue a direct prohibition on marijuana, so rather they imposed a tax on it, and they required dealers to purchase a stamp to prove that the tax had been paid. So marijuana, of course, was illegal in virtually every state, probably every state. And so basically, by requiring dealers to purchase a stamp to prove that the tax had been paid, they were requiring individuals to incriminate themselves. Well, this law and this provision of this law came before the United States Supreme Court in 1969 in the case of Leary v. U.S. And this case involved Timothy Leary, who you may have heard of. He was one of the most famous figures from the 1960s. He was a Harvard professor of psychology or psychiatry who started dropping acid and was using it in his professional work, but then eventually just stopped teaching or perhaps was fired from Harvard. But in any case, he became a leader of the counterculture movement. Turn in, tune on, and drop out was his slogan. And he was prosecuted and convicted for violating the law that we just discussed. Brought this case to the Supreme Court, saying that it violated the Fifth Amendment's prohibition against self-incrimination, and the court agreed. And not only that, it was a unanimous 9-0 decision. The court said the law compelled the petitioner to expose himself to a real and appreciable risk of self-incrimination. And so, although the Fifth Amendment doesn't come up a ton in administrative law, you cannot force people through the reporting and other requirements to expose themselves to criminal liability. However, you could still tax the marijuana, and the government could get around this prohibition simply by putting in place procedures to ensure that the tax information would not be passed on to law enforcement. So by keeping those two functions of government separate, you would eliminate the constitutional problem. Now, the Fifth Amendment, just want to feature this, it does have its limits. First of all, it only applies to people. It doesn't really apply to corporations. It doesn't apply to previously recorded information. So if somebody, say for example, has a videotape that they record, and later the prosecutors or the government finds out about it and they want to get a look at it, the Fifth Amendment doesn't apply. Or if there is a document, a tax document or something that was previously created, the Fifth Amendment simply does not apply to situations like that. Furthermore, this is important, the Fifth Amendment only applies to testimony about yourself, not about other people. So if they ask you if you have done things that are criminal in nature, you can take the Fifth Amendment. But if they ask about your knowledge of the actions of your friends and neighbors and loved ones, the Fifth Amendment does not apply. And just want to point out that the Fifth Amendment only provides a floor, not a ceiling. In certain circumstances, federal and state law provide additional protection in terms of the kinds of information that people can keep private. So again, the Fifth Amendment isn't used that frequently, doesn't come up that much in administrative law. The Fourth Amendment, which prohibits unreasonable search and seizure, comes up a little bit more frequently. The Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So one of the important things to keep in mind is that the Fourth Amendment only prohibits unreasonable searches and seizures. It does not prohibit all searches and seizures, only unreasonable searches and seizures. So the important thing, of course, then becomes figuring out what is a reasonable search and what is an unreasonable search. And we've talked about the fact that courts are there because language is ambiguous. And unreasonable, of course, is an extremely ambiguous, extremely subjective term. What is unreasonable to you might not be unreasonable to me. And so, the meaning of the word unreasonable has been fleshed out by the court over a series of decisions over a series of decades. So reasonable searches are okay, unreasonable searches aren't. What's the difference? Well, first of all, one question that's come up is when an administrative agency comes in to inspect a a facility, or if they test a product, are they engaged in a search? So for example, if health officials come in to inspect a restaurant to see if it is operating in a sanitary manner, or if you have, again, health officials testing hot dogs to make sure that they have less than the maximum amount of rat droppings allowed, are these searches? And the courts have had no problem indicating that yes, indeed, they are searches. And if they are searches, then they must fall under the Fourth Amendment. So they are searches, but businesses do not enjoy as much protection as individuals do. The Fourth Amendment extends farther to individuals than it does to businesses. And that's because most searches of businesses as businesses are not intended to uncover evidence of crimes. If a restaurant is behaving in an unsanitary manner, they're not violating in a criminal way, unless they're doing something intentional. They're simply not meeting the code, and as a result, most searches of businesses, most tests that are conducted regarding businesses are not intended to uncover criminal activity, and as a result, their government has more latitude to engage in such searches because there is a lower expectation of privacy. So, how is a search reasonable? Well, there's one way to guarantee that a search will always be reasonable, and that is if you get a valid search warrant. This is a procedure that's spelled out in the Fourth Amendment that we had up on the screen just a moment ago. Any search that's conducted with a valid warrant and that's conducted consistent with the terms of that warrant is reasonable. And so that's why police, when they can, and even administrative agents, when they need to, get a search warrant in order to solve any Fourth Amendment problems they may have. Now, in some cases, administrative agencies are required to gather search warrants or obtain a search warrant for routine inspections. Like I say, health inspections, safety inspections, typically no warrant is needed. We will discuss in class, and I'll reference in a moment, a case and a situation where an administrative search warrant was required. But even when an administrative agency is required to obtain a search warrant, the standard of proof that it must demonstrate in order to obtain that warrant is lower. As you probably know, that when the police want to get a warrant to search for evidence of criminal activity, they have to demonstrate to a judge or a magistrate that there is probable cause that a crime has been committed. So, and that there's probable cause that they will find what it is that they're looking for. So in criminal cases, the standard that's used is probable cause. And of course, when the police officer comes to a judge to state what that probable cause is, they have to state that accurately. They can't lie. That would definitely have the search thrown out. But as long as the facts are stated accurately, they must still meet that probable cause standard. Not only that, when the judge issues the search warrant has to state the items that are expected to be seized. So it will indicate, that they're looking for, whether it's documents or perhaps they're looking for a shirt or a gun or whatever it may happen to be. That would be contained in the search warrant. And it must also state the location to be searched. And so law enforcement officials cannot search beyond the parameters of what's contained in the search warrant. Now, administrative warrants do not need to be so detailed. They do not need to rise to the level of probable cause, and they can be looser in other respects as well. And there is a case in your book that talks about an interesting case about a guy who was living in the building where he worked secretly, which led to an interesting case questioning whether or not a search warrant was required to look into his place and investigate what he was doing. That's camera versus municipal court, and we'll discuss that in class. Now, getting a search warrant, if it's valid, means that the search is reasonable. But there are a lot of other ways for searches to be reasonable. Search warrants are not the only way, and you could teach a whole course on this, so we're really just scratching the surface here. But some examples of other searches that are reasonable, first of all, of course, are non-governmental searches. As we've discussed, almost the entire Constitution only applies to government. It establishes the procedures of government and the limits of governmental power. So the limits that are placed in the Bill of Rights and in the Due Process Clause and in the Fourth and Fifth Amendments only apply to the government. They don't apply to non-governmental searches. So for example, if you're sending a package in the mail and it's got contraband in it, if you're sending it via Federal Express, a private company, and it has contraband in it, they have the right to open it up, take a look at it, and if they find evidence of illegal activity, they can turn that over to law enforcement, and law enforcement can use that in a prosecution or administrative action. Searches incident to arrest. So obviously most public managers are not going to have to deal with this, but when the police are arresting somebody, a suspect, they have the right to search that person without a warrant to make sure that they don't have any contraband or weapons. There's also something known as the plain view exception. If a police officer or administrative agent is somewhere where they have a legal right to be, and they can plainly see evidence of illegal activity, well, then they can seize that and use it in court, even without a search warrant, because anybody could have seen that. Any search that will prevent a threat to safety would be considered reasonable, and encompassed in this would be there are certain unique places where the courts have said searches can be conducted broadly, they can be conducted without a warrant, and of course I think we would all agree that these places have special safety and security needs, places like prisons, borders, national borders, airports, and so on. So the police have wide latitude and law enforcement have wide latitude to search in these places. And one other place that's almost entirely searchable by police officers with almost few limits are cars. So if you're out driving and you're pulled over for a legitimate reason, the police have wide latitude to search your car. Now, as I say, other than administrative searches and record-keeping and reporting requirements, many of the search and seizure issues are unique to law enforcement that I realize many of you are not going into. But one issue that does tend to come up, both for employees and as public agents administering public programs, is the constitutionality of drug, alcohol, and other testing. Public agencies sometimes want to test their employees and even their clients for whether or not they've been using illegal drugs or alcohol. And that raises interesting Fourth Amendment issues. Now, the court has said that this doesn't raise Fifth Amendment issues. Fifth Amendment issues, of course, are issues of self-incrimination. And you can be ordered to turn over, for example, a strand of your hair or a DNA sample. The court can force you to do that, even if you don't want to do it. And that does not violate the Fifth Amendment's prohibition against self-incrimination, but in certain circumstances it might violate the prohibition against unreasonable search and seizure. Now, drug and alcohol testing raises some concerns because under the Fourth Amendment, searches usually have to be based on individual suspicion. Just broad searches of large categories of people, merely because they belong in a particular category, are not usually permitted. Usually searches are only allowed under the Fourth Amendment if there is some reason to think that the individual being searched is guilty of criminal activity, not because they are a member of a group. And so, for example, the Supreme Court has decided that random drug checkpoints are illegal. Some cities would set up road blocks, and they would have everybody come in and just search everybody's car that came by for illegal drugs. The courts have said that that violates the Fourth Amendment. On the other hand, there are several circumstances in which the court does allow drug, alcohol, or other testing when there isn't any individual suspicion. When there's no reason to think that you've done anything wrong, we're still going to require you to undergo some form of testing. So, for example, while random drug checkpoints are illegal, alcohol checkpoints, DUI checkpoints, are not illegal. And in class, we can talk about why the difference might be between those two situations. Now, one thing that the court has taken in mind is that drug and alcohol tests, particularly drug tests, are invasive and embarrassing. Having to pee into a cup is embarrassing. Having a needle stuck into your arm is invasive. And so the court has been cognizant of that. And of course, they're also worrisome because drug and alcohol tests are often not based on individual suspicion of wrongdoing. Oftentimes, for example, you'll test everybody that's applying for a job or that's hired for a job, and whether or not there's any suspicion that they're using drugs or alcohol. So these raise some interesting constitutional questions. But generally, the court has looked fairly favorably upon random drug and alcohol testing, and your book talks about two such cases: Skinner v. Railway Labor Executives Association, which involves the railway industry, of course, and Vernonia School District v. Acton, which of course involved drug testing in schools. So I ask you to read those cases, and we will talk about them in class. So, again, we've sort of rushed through this, and when we meet in class, we will talk about this at greater length. You could spend several weeks talking about the Fourth Amendment, but just a real quick summary. If searches or tests or other information gathering techniques are being used for the purpose of uncovering crimes, then they must satisfy the probable cause and warrant requirements, or they must at least be reasonable. They must at least fall under one of those other exceptions. But if the tests are merely administrative, all they have to do is be reasonable, which means the court merely in these cases conducts what they call a balancing test. This is, again, a very subjective test, but what they do is they say, well, how invasive and how offensive is this test? And we balance it compared to the danger that the government is trying to avoid. And so we'll talk about that, of course, when we talk about the drug testing cases. But in that case, in those two cases, you'll notice they talk very much about how invasive and the non-individualized suspicion things are balanced against the danger that the school district and the railway system are trying to avoid by engaging in drug testing. So the upshot here is that the standard for the government is higher in criminal cases than it is in administrative cases. Now finally, your book has a couple of cases in which they talk about closely regulated businesses. Not always doing drug tests of children. Oftentimes, we're investigating businesses, of course, and the section on closely regulated businesses relates solely to inspections. So we're not talking about drug testing or anything like that. And basically, here, there are some businesses that are more heavily regulated than others. They're called closely regulated businesses, and these are things like the railroad industry and the mining industry and the oil industry, where typically they tend to have lots of potential for danger, physical danger, if you will. So there are some businesses that are heavily or closely regulated, and in those businesses they have a lesser expectation of privacy than other businesses do. So again, it's not a huge deal, but your book does have a couple of cases on this topic. One in which the court found that it was a heavily regulated business, the other in which it wasn't. So the important thing to look at here is how do they distinguish between a heavily regulated business and one that is not. And the two cases are Donovan v. Dewey and City of LA v. Patel.